So now the time has come to the third speaker, Mr. David Lewis. Where do you sit? Somewhere? There you are. Mr. Lewis is a professor in law, labor law, I think, and very experienced in whistleblowing matters and freedom of speech. You are here in Norway now, attending a conference with Fafo, as I understand. So, and you will say some words about maybe the British experience or European, and we look very much forward to hearing that. As I mentioned, afterwards there will be a panel debate, which will be in Norwegian, so that might be difficult to take part in. So maybe instead I might have a question or two after your speech. So please, Mr. Lewis, the stage is yours.
Okay. Lost it? Am I losing it? I thought the Norwegian was going to be the difficult bit. It's the middle, I think. Middle is great. Thank you very much. Yeah, Norwegian was the problem. Never mind the technology. Thank you for inviting me for the introduction. I'd like to say, particularly to Fritt Ord, who are sponsoring the conference, International Whistleblowing Research Network conference being held over the next 2 days. I'm delighted to be here. I was quite amused to hear reference made to legislation in England, Great Britain and the UK. Maybe people know more about Brexit than I do, but at the moment it's the UK, but if the UK comes out of Europe and Scotland stays in Europe, we may be talking about Scottish whistleblowing legislation, which I think 2 years ago would have been regarded as a joke. Does the UK legislation provide a suitable model? The short answer is no. A lot of people in the UK think so. It may have provided a model 20 years ago. It certainly doesn't now. We're coming up to 18 years in force, and I think it's now recognised throughout the world, and most seriously in Brussels, that the UK model is not good enough. So the question is, what can we learn from it? I'm going to start off with some positive features. You will see that there are a total of 3 pages here, 1 page on positive features and 2 pages on negative features, which just about sums it up. But it mustn't underestimate the positive features. First of all, the UK covers private and public sector, irrespective of the size of the organisation, which is quite special. There are rumours that if there's new legislation requiring mandatory procedures, that there will be a small firms exception. But at the moment, mandatory procedures are not in force, and there's general coverage. There's a broad definition of workers, the broadest definition of the whole of UK employment law. Maximum protection is given for whistleblowing purposes, even wider protection than for discrimination claims under EU law. But interesting, there's no protection for non-workers. The whistleblowing legislation in the UK is about whistleblowing at work. It's not about freedom of speech. It's not about Article 10. It's not about the citizens' human rights. Very specifically, it's about speech at the workplace, which raises interesting questions. I had the privilege I've done research in the public and private sector. I had the privilege to do the research for the NHS study on speaking up at work. The NHS is the 4th biggest employer in the world. And one of the things that emerged, that in a health context, there are many people who might see wrongdoing, whether it's medical wrongdoing, financial wrongdoing or whatever, some of whom will be workers under the legislation. Others will be patients, members of the public, who will have no rights under this legislation. They may not report because they feel there may be victimisation of the pay of the patient or themselves. So we've got to be very careful to ask the right question. Who may observe whistleblowing? Who may observe wrongdoing at work? It may be workers. It's likely to be lots of other people. And they are currently not encouraged by the legislation to report. Indeed, they may be deterred. This is a big question for European legislation, who should be covered. As many of you will be aware, the EU Commission is currently looking at the feasibility of a directive, and no doubt this question of coverage will come up. I am aware that the Commission officials know of the problem of non-workers not having rights to report workplace wrongdoing. There are key features of whistleblowing legislation, and Norway has, I think, by and large, kept away from the big traps. One of them is to focus on the motive or intention of the whistleblower, saying that the whistleblower must act in good faith. The problem is we don't know the whistleblower's intentions. How do you ascertain the intentions of a whistleblower? Maybe the intentions of the whistleblower change. If you report internally and you are rejected, perhaps you adopt a different attitude to your employer. The UK started off with a good faith test, which caused all kinds of problems, including reporting by a woman of a financial irregularities. Her case got to the Court of Appeal. The Court of Appeal decided that she had a grudge against her boss who didn't promote her, and they said she wouldn't be protected. What the Court of Appeal didn't say is that there were no financial irregularities. We don't know whether there are financial irregularities because the case was about the motivation of the whistleblower. What's important in whistleblowing is the message, that the message is conveyed, that the concerns are investigated. What is not of interest is who the whistleblower is. The most important thing to say is if you are interested in motive, you've got to decide how you're going to investigate it. I think it's irrelevant, and I hope that the EU legislation will not contain a good faith clause. A positive feature in the UK, and it's a relatively recent change to the legislation has been changed very little, relatively recently, in recognition of the problems that arose in case law. Employers are now vicariously liable for reprisals taken against whistleblowers by their staff. So it is good practice to have a whistleblowing procedure, but not required by law in either the public or private sector in the UK. However, employers are going to have to be able to show they took reasonably practical steps to make sure that there weren't reprisals. And this, in my opinion, involves having a procedure, training people in the procedure, and checking that procedure that people are aware of their obligations and they don't infringe the rights of whistleblowers. So employers are vicariously liable for reprisals, and we've yet to see the impact of that. Moving to negative features, and I've already alluded to some, I'm afraid. In the positive features there was also the sting in the tail. There's a public interest test in the UK, a public interest test. Now, we could sit here for days on end and have a conference about what a public interest means in a workplace context. Indeed, my starting point is, well, if you have a public interest test, how does that apply in the private sector? If I'm a private sector employer, I want to hear about wrongdoing in the interest of the stakeholders and shareholders. I want to deal with the wrongdoing before the share price drops. I don't want people to report in the public interest. And so we have procedures in the UK that are perfectly adequate and indeed very impressive. They don't refer to the public interest. So we have a major problem. There's a public interest test, and if I'm going to advise somebody, I will not be able to tell them definitively that they will be protected. I can say, well, I think this is important, I think it's of public interest, but if a tribunal decides, if you bring a case, if the tribunal decides it wasn't in the public interest, you have nothing. Questions arise here, and I flagged them because it's going to be an issue in Europe. I'm not sure it's an issue really in Norway, about the burden of proof. If there is a public interest test, does the employer have to show there was no public interest? Or does the worker have to show there was a public interest? Burden of proof is critical. in many legal cases, but particularly in relation to whistleblowing. The same will apply, of course, to any good faith test. Who has the burden of proof? It seems to me that the good faith test and the public interest test are inappropriate, but if they do exist in legislation, the burden should always be on the employer. Another curiosity in the UK, that to be protected, workers who disclose to a regulator need to know the correct prescribed person. Okay, how do you find that out? Well, the relevant government department produces a list of prescribed persons and their responsibilities. Unfortunately, they've had great difficulty keeping this up to date and keeping it accurate, and there are research studies showing that at least 3 of the 53 regulators deny they are prescribed persons under the legislation. I find that truly shocking. But it shows what happens when you go to regulators, give them additional duties and don't give them any money, you don't tell them what they're meant to be doing, they therefore sideline it. Again, there's been an intervention now saying regulators must produce information about who gets to them. One obvious remedy would be to say that if a regulator or prescribed person receives information that should be more appropriately dealt with by another regulator, they should have an obligation to transfer that. This is not rocket science. This is what other countries do. This is what happens in Australia. It's got to be common sense. Again, some kind of this reflects very badly, I think, on the UK legislation. And in Norwegian context, probably amazingly enough, employers are not obliged to have a whistleblowing procedure. Even if it's in their interest to do so, they're not obliged to have one. Of course, such procedures are prevalent in the private sector as well as the public sector, and many employers will get hold of a template, they'll copy out the procedure, and some, of course, will buy into it and some won't. But in the UK, we have a situation where the sole purpose of the legislation is to protect whistleblowers. The legislation is not designed to encourage whistleblowing. It's not designed, it doesn't require concerns to be investigated where they're received, and even worse, does not require remedial action. So what the law requires in the UK is that if a person raises a concern, they shouldn't be victimised. The employer is entitled to say to me, if I raise a concern, thanks for raising the concern, Dave, we'll deal with it, and then do nothing. Absolutely nothing. They may have other statutory duties or whatever. And even worse, in my opinion, if there is victimisation, the UK says that I'm entitled to compensation. The employer can simply throw money at it, and we know multinationals have done this in relation to the US law as well, but there's no sanction on an employer who simply says there is wrongdoing, I'm not dealing with it, or yes, I've victimised you and I'm going to pay you, you've lost your job, you're unemployable. Page 2 of the negatives, and there is one more page that's not negative. No discrimination at the hiring stage. Apparently this is going to happen in the health service. There was a proposal for dealing with this. But when it comes to discrimination on any other grounds in the UK, sex, race, all of those under the framework directives in Europe, sex, race, nationality or whatever, there's protection at the hiring stage, even for trade unionists at the hiring stage. But an employer is entitled to openly say, I am not taking you on because you're a whistleblower. I find that truly shocking. No protection, in addition, for those who haven't made a protected disclosure, but have made it clear they're going to make a protected disclosure. No protection for somebody who is wrongly thought to be a whistleblower. Sometimes you get anonymous reporting, sometimes you get confidential reporting, and people come to conclusions. So if you want to protect whistleblowers, the UK actually barely does it. It does the absolute minimum. It says, if you've got a job and you suffer a detriment, you may get some money. Something that I feel especially strongly about, given that money can be thrown at whistleblowers in the expectation they'll go away. I believe there should be a criminal sanction for retaliating against whistleblowers. People have said this is extreme. I know many people, certainly European Commission discussions saying we've got to keep the criminal law out of whistleblowing. We don't. That's too scary. But the short answer is that if you can throw money at whistleblowers, if you can throw money at the problem, the people at the top are going to carry on as usual. They're not threatened. The problem goes away if you throw money at it. I think in the boardrooms, if there's possibility of individuals facing criminal penalties, this may have an effect. I'd like to point you to the fact that in Australia there are criminal sanctions. And like many bits of legislation in Australia, like compulsory voting, the criminal law doesn't have to be invoked. The message goes out, take this seriously. If there's a possibility of a criminal sanction, maybe you get action. So I don't think they're going to be, I don't think we're going to see employers imprisoned very often, but the fact that they could go to prison, I think, is important to have on the statute book. Lastly, on this page, in the UK, I said the sole purpose of the legislation is to protect whistleblowers. It's not to facilitate whistleblowing. It's not to deal with wrongdoing, and there is no provision at all for monitoring or reviewing of the legislation. Yeah, I'm getting the warning here. Yeah. Well, it's 20 years of legislation, Sissel. I mean, somebody said, tell everything you know about 20 years of legislation in 5 or 10 minutes. Okay, this is the last one. A general point, very, very speedily. I was asked recently, if you could make one change in relation to protecting whistleblowers in the UK, what would it be? And the answer is don't touch the whistleblowing legislation. Just allow people access to justice. Get away of tribunal fees, give them legal aid. It quite simply, people have to pay a fee to bring a case to a tribunal. It inevitably deters. It was designed to deter. We don't have a specialist advisory or enforcement agency. A whistleblowing ombudsman might be considered. I've said enough on that. And lastly, if you've got legislation, you've got to publicise it. People don't know their rights. This isn't the only employment right that people are unaware of. But the survey by Public Concern at Work showed that less than 50% of those surveyed were aware legislation existed. This is after 18 years in force. So, a fairly pessimistic view of the model, but I'm happy to take questions about what might be in future legislation, particularly a possible EU directive which is currently being discussed.
Thank you so much. Please just stay there. I promised you one question at least, so here it is. You criticized the test, British test, or the criteria threshold, one of them at any rate being public interest. And there will be questions about burden of proof, and there will typically, as I understand it, be a discussion then about the test itself and not the message. And similar in Norway, we have trouble with the thresholds and the tests. Among other things, one of the tests is the whistleblowing about something reprehensible or not, kritikkverdig. And we've had cases where the discussion then turned out to be a discussion about that. Is it a debate about something reprehensible or not? Do you have a suggestion for a good test? Or should the whole whistleblowing legislation just be a general freedom of speech?
Okay, I like the question.
Yeah.
You may not like the answer. The legislation in the UK was called the Public Interest Disclosure Act. Probably be aware of that. And we talk about public interest tests. But the legislation defined the public interest as the reporting to a designated recipient of certain matters, so that the matters that could be reported were listed. So you acted in the public interest if you reported one of the list, I think it was 8 types of wrongdoing to an appropriate recipient. There was no separate public interest test. So I think you satisfy the public interest by saying this person has reported something that's listed in the statute, which would cover a breach of the law, it may cover gross mismanagement, but there are obvious things there. So I think the argument is not whether you should have a list of what can be reported. Then you could advise people and say, that's on the list there. The argument should be not what should be in the list, but whether there should also be a catch-all that you say that people have the right to report wrongdoing, and you give examples, but they're not exclusive. So that I think is where the debate is. A statute that I would put on a pedestal is the Irish legislation, which does lots of other things, include protecting the family of whistleblowers. But it adopts that approach that people have to know what can be reported. You have a list, whether it's exclusive or not exclusive list, but they have to be able to look and say, yes, it ticks that.
Okay. Thank you so much. We could discuss that,
Yeah.
but time is flying. Thank you so much.